Knowledge is power, information is liberating, so said Kofi Annan. Information is often interchangeably used with data and knowledge. Not just for individual benefit, a well-informed citizen is key to a balanced modern society. In this episode, we delve into one of the most important legislations in modern India, the Right to Information Act 2005.
So now let's deal with the basics of Right to Information Act. So the Right to Information Act as such was enacted in 2005, and it extends to all states and union territories except Jammu and Kashmir. And for Jammu and Kashmir, it has its own act which was enacted in 2009 and which is also based upon the RTI Act as such. And each state follows the act but has its own rules which are relating to the filing procedures, the fee payments, etc. And the law was also enacted with the objective of providing Indian citizens the right to access information from the government departments and public authorities. So, with a view to promote the transparency and accountability in working of these departments, which including the optimal utilization of funds and other resources which have been allotted to each public authority and the government department as such.
Subathra, you had mentioned that the core of the RTI is to enable every citizen to access information from every government department or public authority. Yeah. Now, that is the crux of the act. For that, as a citizen, it is important for us to understand who or what will constitute a government authority or a government department or a public authority. Right. Now, the act, the RTI Act, defines a public authority, and I quote, as any authority or a body or institution of self-government established by the Constitution or laws made by the Parliament or state legislature, and includes any body owned, controlled, or substantially financed, directly or indirectly, by the government. And when I say this definition, it brings under the ambit the NGOs as well. Right. Now, for instance, we'll give some examples for a better understanding. The union and state executives, namely the president, the vice president, the prime minister, and the council of ministers. The election commission, central and state universities, the RBI, SEBI, TRAI, UIADI, which generates Aadhaar, etc. All of them will come under the ambit of the RTI. So anyone seeking information can file an application for these respective departments and many more such departments and get the information that they need to access.
So there have also been several instances of schools, colleges, universities, registered cooperative societies like Gymkhana clubs, sports associations, which were also considered to be private, but they were all brought under the scope of the RTI. So even the office of the Chief Justice of India will come under the purview of the RTI Act as such. And there is also a landmark judgment which was passed by the Delhi High Court in the case of CPIO versus Subhash Chandra Agarwal, which was upheld by a 5-judge constitution bench of the Supreme Court.
Right. So, Badra, the next logical question that arises is, if a citizen has a right to access information with every government department or a public authority, whom should he or she approach in the respective department? For this, under the RTI Act, every public authority shall designate one or more of its officers as public information officers, or PIOs in short. So likewise, if it's a central government department, then the central government shall constitute a Central Information Commission. And similarly, each state will have its own State Information Commission to whom applications can be addressed to.
Correct. Now, the next step is who can file the RTI application as such. So, it is to note that only Indian citizens can file the RTI applications, and there is no age limit for any kind of filing the RTI application. Even minors can file the RTI application, and there was also a case of a 9-year-old who was filing for an RTI. Also, a case of a 13-year-old schoolgirl in Kollam who was filing for an RTI application, seeking her cash reward of rupees 100, which the education department did not give. So, this is the kind of the power which the Act as such has.
Absolutely.
And after filing these RTI applications, she has got it in the next few days.
Right.
So the Act also has got its power to use it in a very appropriate manner. We need to know how to use the Act, and it is extremely powerful as well.
Yes. We've been talking right to information, that every citizen has a right to access information from every government department and public authority. But now it's most important for us to share with our viewers the mode and manner in which this information can be accessed. Okay, and why we access it and how we can access it. First, the right to information means we can access information. Now, information we can access for the purpose of inspecting documents, works, or records, taking notes, extracts, or certified copies of documents, take certified samples of materials, and obtain information either in the form of printouts, or, back in the day, there were diskettes and floppy drives, tape, video cassettes, or in any other electronic mode, or plain simple printout. So these are the mode in which information can be sought from any government department or public authority.
Now, the next step is we need to know how to request for this information. So, first is we make an application to the concerned public authority. Either it is made by the way of an application in writing, and the application is also accepted through an email.
Right.
The second is the language of the application. It can be in English, Hindi, or the official language of the area in which the application is being made.
There is always a doubt if there is a pre-printed format or a prescribed format to writing or filing an application. Let us make it clear to the viewers, there is no such prescribed format as such. However, the application has to be, if you are making it in writing, it has to be made on a plain white sheet. The most crucial information that needs to be stated correctly is, of course, the name of the applicant, the complete address, the phone number, and the email ID. These contact details are most crucial. And another equally crucial information is the place and the date of when the application is being made or written is most important. We will discuss in the later part of the Act that the revert has to come from the public department within 30 days. So the place and date becomes very crucial from this point of view.
Right. And also the payment of the prescribed fee is usually 10 rupees for the application. But then again, it may vary from state to state, and citizens who are below the poverty line need not even make this fee payment. And all they have to do is just attach their below poverty line certificate status.
Right.
And the application also can be made to the public information officer, either in the central or on the state PIO.
We now look at the time limit to get the information access. Normally, information must be supplied by the public information officer within 30 days from the date of receipt of application by the public authority.
Now, if the information relates to life and liberty of any person, then that information should be made available within 48 hours from the receipt of the application. And it has to also be noted here that if the application has been sent wrongly to an authority, or the application has been transferred within the departments of public authority, and additional 5 days will be added to this 48 days which has been usually provided. Now this application can also be made where there is an imminent danger to life or liberty of a person, and the non-supply of the information may either lead to death or grievous injury to the concerned person.
Okay.
So this is a very, very important aspect which has to be noted under this act.
Right. What happens in case of failure to provide information by the public information officer or the PIO? Now, failure to provide the information within the stipulated time that we just discussed is actually considered as refusal to provide information. Now, that will attract a penalty of a minimum of rupees 250 per day up to a maximum of 25,000 rupees. Now, even disciplinary action can be initiated against the public information officer, namely temporary, termination or suspension or, penalties, etc.
Now the next is, what are the remedies if the applicant has not received any information even after the application has been filed with authorities? So if the applicant has not received any kind of information within the stipulated time, or they have denied access to the information which they have sought, or it is being charged with an unreasonable fee, then the person can file an appeal to a senior ranked central or state public information officer. And now this must be done within 30 days after the expiry of the 30 days of when the information was supposed to be received. Typically, the appeal shall be disposed of within 30 days thereafter. And in exceptional cases, it will be disposed of within 45 days from the date of receipt of the appeal.
Right. Subathra, you were mentioning about the timelines for redressal and appeal. Okay. Right. Now, if the appeal filed is not disposed of within the said timeline, or if the applicant is not satisfied by the decision of the appeal, then we wish to bring to the notice of the viewers that they have the right of a second appeal. Now, the second appeal has to be or can be made to either the Central or the State Information Commission, depending on the authority or the department to which the information is sought. Now, such second appeal has to be made within 90 days from the date when the original appeal should have been disposed of.
Absolutely.
Subathra, as a citizen who may want to file an RTI application in future, I have a question. Am I entitled to file an application seeking any sort of information? Will I be able to access any and every information?
No, not at all. Not all information that is sought can be provided. The public information officers may reject any application which is seeking for any information if such disclosures will affect the sovereignty and integrity of a country, the security of a country, or if there is any kind of economic interest which will affect in a country, or it would lead to any kind of inciting to any kind of an offense. And also any kind of information which is being forbidden by the court to be published or by the tribunal, it will also amount to contempt of court. And the other thing is also the information on such as trade secrets, intellectual property, and commercial confidences cannot be disclosed to the public. And for example, banks cannot be asked to disclose its agreement or details of its customers on grounds of commercial confidence.
Right. So whether it is pertinent to note here that there are certain exemptions itself under the Right to Information Act. For instance, the RTI Act does not apply to intelligence and security organizations, except if it violates human rights and or there are corruption charges that one needs to know about. Okay. Secondly, when we say we can get information about officers of the public authority, personal information of officers of public authority are exempted under the RTI. For example, I can know of the leave availed by the officer of a public authority or a government department. That has to be disclosed. But the purpose why he availed the leave need not be known through an RTI application, as in it is exempted. So there is no point in making an application for that. And that need not be disclosed.
Sandhya, now let's look into the gray areas. I mean, most of the acts do have their own gray areas. The same applies here under the RTI, where there are certain loose ends. Now, the time limit is of 30 days for receiving any kind of information has been put in place in order to ensure a speedy disposal of information which is being sought after. However, given to the state of records and the preservation and the management of the large volume of information in government offices, there could be a genuine delay in supplying these cases as well. For this, every public authority should maintain a website and upload the most relevant information there for easy access, And the 30-day time limit could be a boon and a bane. That we need to understand that aspect. The other thing is the time limit within which the second appeal must be heard is not mentioned, leading to a substantial delay, Yeah. And any insufficient number of qualified information officers, they also pose as a big challenge here in understanding the requirements of information which is needed. So all these will lead to an increase in number of first appeal cases.
Absolutely.
So it is very important that we have qualified information officers in order to have a speedy disposal, I must say.
Right. Subathra, you had rightly mentioned the RTI Act as well as the timelines as the facility to apply is actually a boon. It can be a boon, but several times can be a bane as well. So while we urge every citizen or every viewer that is watching this episode that they have their right to file an application under the RTI, we humbly request them to do so in an objective manner. There are two aspects to this. One is there have been several instances where information has been sought on employees of the government department or senior officials purely with the intention to harass them or sue them or extort money from them. So the end use has never been for the final good. Okay, so that must be that is not recommended at all, and that must be absolutely avoided. Secondly, is the aspect of frivolous applications. As I even mentioned this to you, there has been. I can share some examples where there've been, attempts for frivolous application. For instance, there was a person who had applied to state government asking for a list of all eligible government employee women who are eligible to marry. Okay. And then there was another instance where one under employee filed an RTI asking for the tobacco chewing habit of his superior. Bizarre as it may sound, it just serves for a good laugh. But then one has to realize it takes away such precious time of the government departments, because they cannot not reply to these, or they cannot not even go over these. So they will reject it, but it basically takes away the time. So we urge our viewers who are also citizens to apply to the RTI to please do so in an objective manner.
Absolutely, yes. So to sum it up and to conclude, the right to information is not included as a fundamental right in our constitution, yet it is ingrained as a part of a fundamental right to freedom of speech and expression under Article 19 of the Constitution.
Right.
While Article 21 it deals with the right of life and personal liberty, and it also includes right to privacy. So the RTI Act must attempt to maintain a delicate balance between transparency and privacy in order to achieve the objective of which it has been enacted and to make our democracy work as well.
Right.
So we hope the viewers have found this episode useful. Thank you so much, Sandhya, for joining. And thank you all for watching. See you next time. Bye.
Thank you. Bye.